Thank you for joining Jennifer Schaus and Associates in our 2019 Webinar Wednesday series. We are coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and our recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email him directly with the contact information you'll see on the last slide. All right, this is just a little bit about us. We are a Washington, D.C. based firm and provide services for federal contractors. This ranges from market analysis reports to proposal writing and also post-award compliance. More information is on our website, so please visit us there. And these are a couple of upcoming events that you can find more information here, also on our website. And we do offer advertising in our newsletter, so you can send us an email if you'd like more information on that. All right, our speaker today is Anthony and Keith, and he's going to be covering legal playbook for teaming agreements. Anthony, thank you for joining us, and I'm going to go ahead and hand it over to you.
Thank you very much, and thank you for joining us this afternoon for part of your day. I'm Tony Anikeff. I co-lead our government contracts practice, and I have the privilege to work with small and emerging and large businesses, both domestically and internationally, throughout the life cycle of government contracts. Today, we're going to be talking a little bit about the details of teaming agreement. This is a companion program to another program we did, which focused on the larger context of teaming agreements and subcontracts. Why don't we dig in? And next page, please. So in terms of what we'll cover, we're going to focus a little bit on putting a teaming agreement into context, the teaming agreement process, why folks should team, some of the general considerations, enforceability, the scope of the agreement, some of the terms, and then some special circumstances. If we can go to the next slide, please. So let's start with what a teaming agreement is. It's actually not defined in the FAR, and there are two types. There's a vertical teaming agreement, which is between a prime and a sub, and then there's a horizontal teaming agreement, which is really comprised of a joint venture through a partnership or a joint company. But in terms of the FAR, the FAR defines something called a contractor teaming agreement, which really in those two paragraphs sets out both the horizontal and the vertical type of teaming agreement. The teaming agreement itself, which is not defined, is simply the document that memorializes the agreement that is this team arrangement. I think it's important to distinguish it from a subcontract, which also is defined in the FAR, which is the contract that we're seeking to enter into through the teaming agreement, which will set out the obligations first between the prime and the sub in order for the prime to carry out its obligations to the federal government. And then a subcontractor, that would be the party entering into the subcontract, both the prime and the lower part, the subcontractor. And it's important to note that the FAR includes far more than just the party performing part of the work. It includes suppliers, distributors, and vendors, which may be a surprise to some parties. Let's continue, please. Next page. So the teaming process. I note that because it's a bit of a surprise to us that we get calls to draft up a teaming agreement or even a subcontract, seemingly more because it's the thing to do rather than as part of a thoughtful consideration of the circumstances in which a company finds itself. A teaming agreement really needs to be placed into the overall consideration of one's business goals, which are going to vary based on one's circumstances. And it can vary considerably whether you're a small or a big company, a prime contractor or a potential sub, a new entrant into the market or an experienced one. But the first issue is, do you even need to enter into a teaming agreement? Because certainly if you can do the work yourself, that retains the control and the revenues that might be the ideal situation. If you decide you need to engage in teaming, it's important to do market research and not just date the first person that comes along who says that they're capable. You need to do a little market research. The other aspect is you'll be sharing confidential and proprietary information in the process, which you need to protect. And that's done through a non-disclosure agreement, which sets out the respective duties, rights, and remedies of parties sharing their confidential information. Something that is often overlooked or underdone is the need to engage in due diligence. It's important that you find out about the person that you're going to be trusting to do some of the work on your prospective subcontract. And that can involve something as little, certainly a minimum, of checking SAM to see if they're excluded from doing business with the government. You also can get Dun & Bradstreet. You can search them up on the internet. If it's significant enough, you may want to interview them, and you may want to interview some of their customers. Once you've gone through that process, then you should be in a position to begin the process of engaging in a teaming agreement and then hopefully leading on to a subcontract. Next page, please. So why should you team or not? You know, it depends on your perspective of what you're going to do. You need to consider it in the overall perspective. And as I said before, your perspective may be very different based upon the situation that you find yourself in. There's certainly a lot of pros for entering into a teaming agreement. That list can be broken down, however, really into two categories. The first is to expand your skill set or bench of workers to address particular needs of the government customer in terms of technology or workforce. And the other aspect is to reduce risk, both to reduce the risk of cost of developing a proposal and then share the risk of loss if you don't win. All are good reasons. And if you're a small business, this may be the ticket to you entering into a new market area. There are, of course, negative aspects. The fact is that when you give up doing it yourself, you lose some independence and control over the process. You have to work with somebody else. You're dependent on others, and with that comes the possibility that they might let you down. You lose the benefit of growing internally, a skill set that you might wish to have later on. You have to share some of the revenue and the profits, and you risk the possibility, despite an NDA, which will continue through the teaming agreement, that you might lose some of your proprietary information, and you also might be creating a competitor. Next page, please. Next page, please. Let's look first at the horizontal team, which we mentioned earlier. That's really a joint venture. And a joint venture is the creation of a new entity. It can be a partnership. It can be a new LLC or a new corporation as a new identity. Whatever you do, partners, membership, shareholders, they assume liability for each other's conduct. In the case of an LLC or corporation, they may limit the liability of the entities which formed them through the benefits of incorporation. Initially, it has no past performance or experience of itself, so you need to find out whether the agency with which you're dealing will allow you to use the experience of those who have come together to form the JV. There's no particular FAR definition. There are JV definitions littered throughout the FAR depending on the circumstances. They can be populated or unpopulated, and that's become kind of significant. A populated joint venture means that the joint venture itself hires persons both to do the administrative work and the substantive work on the expected contract. An unpopulated one allows you to have administrative personnel, but no substantive workers. This has become important because the SBA has now barred the use of populated joint ventures under its small business programs, both the mentor protege and the dual small business program, because of concern that if one has a populated joint venture, the small business will be shut out of the process. Next page, please. So the key terms of a JV, they're not particularly extraordinary. They're pretty much like the operating agreement or bylaws that govern the company of which you are all a part, or each of you are a part. One has to talk about the scope of work. You know, what is the purpose of this JV? It's usually the fact to pursue and perform a particular contract or series of contracts. You need to talk about the ownership. the distribution of what's going to be invested, contribution, sweat equity, or finance, and of course, what's the return on investment? What's the distribution? They don't all need to be locked up in harmony, but they need to be addressed. Who's going to control and manage the organization? How's that going to be handled? What happens if a member of the JV wants to bail and leave? What happens at that? And how are you going to create a succession plan? What are the liabilities? They're tax liabilities, liabilities for performance and the like. How are you going to divvy that up? How long is the term going to last? And under what circumstances can it be concluded? Those are all terms that probably exist in your own companies and certainly in any JVs that you're a part. I would note that to the extent that you're going to participate in one of the SBA programs, Mentor Protege or SBA, there are a number of other special requirements that we'll address in the process. Next page, please. So the first of the special programs is the All Small Mentor Protege. It was created in 2016 as an expansion on what used to be the SBA's Mentor Protege program, where small companies who were part of the 8A program could mentor with a larger company. The current program basically allows any entity, but usually a large entity, can apply with a small business to create a small business joint venture whose purpose is for the larger entity to supply assistance to the smaller entity in performing contracts. Basically help to develop its skill sets and capabilities. In return, it has to provide assistance, and it can own up to 40% of the protege firm. It leads to a written JV agreement, which has to ID the small business needs and the assistance to be furnished. All of this needs to be approved by the SBA before one enters into a contract. You're required to provide annual reports, both the big business and the small business. It can last for 3 years and in certain circumstances be extended for a 3-year option. There are requirements to deal with the potential that the small business becomes no longer small during that process, but it's something that can last for a good while. The team can also pursue small and specialized business opportunities such as those, if you're qualified, for service-disabled vets, veterans, women, and things like that. It's important in this program, particularly, that the entities maintain compliance with the program. There are a number of instances where a mentor has been disqualified from participation in the Mentor Protege program for failing to provide the required assistance, and there are an increasing number of False Claims Act cases where parties are playing fast and loose with the rules. The Small Business Set-Aside JV program has been around for a while. Its intent is to allow 2 small businesses that are small in their particular NAICS code for solicitation and under other circumstances to combine forces for 3 contracts in a 2-year period to obtain business. And then they can create new joint ventures going forward. There are a number of rules that apply to that, but it's another example of horizontal teaming. Let's turn to the vertical teaming agreement. Next page, thank you. What are the general considerations for them? First of all, it's important to note that in a vertical teaming arrangement, the parties retain their separate identities, Company A and Company B. It's a situation where one remains the prime and the other's the sub, and in theory, a teaming agreement's a commitment by a prime contractor to engage with the sub if awarded the prime contract. I mention the concept of in theory because this is the area where there's the greatest number of lawsuits and disputes between prime and sub when a subcontractor finds that it has not been given all of the work that it expected to get. And the results of those are often disappointing for the subcontractor. So as one thinks about that, one needs to keep in mind that there's no cookie cutter solution, that each one of these agreements should, but all too often does not involve consideration and a negotiation that's unique to the situation, which should reflect the tensions that exist between a prime and a sub for flexibility, enforcement, and escape enforceability. The prime, for the most part, wants flexibility and delay so that it might switch horses if it finds a better partner going forward. The sub, of course, wants to engage and get a commitment as soon as possible to kind of wrap things up. And of course, the situation can change significantly, however, if the prime is negotiating with a potential subcontractor who is essential to winning a particular award because of its skill set. In that type of situation, the prime, in fact, also will want to tie up the sub. And both, of course, would like to have some escapability if things don't go well, but don't want to make that too easy so that they can leave each other in the lurch. If one's done properly, this gets manifested in the precision of terms, enforceability, and escapability that's reflected in a teaming agreement. Next page, please. So the key thing to keep in mind about a teaming agreement is the most critical issue. It's the concept of enforceability. Throughout the United States, the biggest challenge for teaming agreements is their enforceability because courts across the country have different views about that issue. In this area, Virginia, Maryland, and DC, all of the courts are strict in their requirement that one essentially has to lock up the terms of a subcontract in order for the teaming agreement to be enforceable. If you leave situations and have clauses like, if the prime contractor wins an award, it'll agree with the sub to negotiate in good faith for 60 days, and if that fails, the prime can simply cancel the teaming agreement. If you don't come to an agreement on the statement of work with some precision, that can lead to an unenforceable agreement, as can a situation where you don't agree on price, or if you can't agree on price, an objective means by which you would determine price. There are also other terms that one would want to add, and the ideal in this situation is to attach, as I said earlier, is to attach to the teaming agreement a fully agreed to subcontract. And if that's not possible, then attach as many of the terms of a subcontract as can be agreed to, which often includes a great many of them. To the extent that you can't get enforcement of the entire agreement, it's important to note that courts will enforce parts of it, often the duty of good faith and fair dealing, and that can give a cause of action against a party that doesn't negotiate in good faith, and can lead to possibly the creation of a constructive trust and disgorgement if one wants to get into the weeds about potential litigation. One also could include clauses, as I meant before, for liquidated damages. Looking outside of the local area, New York is always thought of as a looser organization in its willingness to treat a teaming agreement as enforcement. It certainly involves a situation where they are looser on the price terms in what might pass muster. If one has a process for determining price, that might lead to an enforceable teaming agreement. And California, which often leads the nation in these kinds of things, is the most loose. It has even allowed the enforcement of an oral teaming agreement, a practice that we would not suggest those who work with us using. What's important from this is that negotiating a teaming agreement and its choice of law provision become critical, because that can affect the outcome of how these matters are going to turn. Next page. So in terms of the teaming agreement, we're going to talk more conceptually than the specific terms. We'll get into some of those in a minute. But how can you go about enhancing the enforceability of an agreement? The one I like to note is the preamble or the recitals, which is all too often the stepchild that is left out of consideration of the terms as a substantive part of the agreement. It's in fact a very useful part where you can set out the history of how the parties came together, what they expect to do, the kind of work they get to do, and most importantly, their commitment and intent to enter into a binding subcontract agreement. It's important to talk about the term and the duration and termination, particularly termination, because as we noted before, one can't have a situation where one is going to negotiate in good faith after an award with the hope of agreeing on a subcontract and then allowing termination. one in theory can eliminate that clause entirely as a basis and have only other objective bases for termination. Exclusivity is important. It is something that can help with an enforcement agreement if one has guaranteed that one will only enter into a subcontract with a particular subcontractor or a prime contractor. Mandatory subcontract language, mandating that the terms of the subcontract will be included in the teaming agreement or attached to it. And of course, the critical parts of the subcontractor work share. Not so much a percentage, but actually getting into the weeds and talking about the scope of work tied to particular portions of the expected prime contract. Percentage of work, although it passes muster in some circumstances, is something that is sometimes looked at askance. Subcontractor pricing is often difficult to determine at the teaming agreement, but if one can, if not come up with tentative pricing or pricing that could be amended based on the level of performance by a subcontractor, then coming up with an objective set of standards for how to determine price may also work. There are a host of other subcontract terms that we talk about in the other seminar, and to the extent you can include them, many are not contentious and can be included so that as an attachment you can put together a fairly good document. As I said, the remedies are important because if things go south, one doesn't just want to go into court where the chances of enforcing the teaming agreement are slim. One may be left with only being able to litigate about good faith and fair dealing and seeking to get some kind of trust or disgorgement, perhaps unjust enrichment. The more that one can agree to the terms of a subcontract, the greater the likelihood of having the whole agreement enforced. And of course, this will all depend on the choice of law that you have negotiated. As I said before, the ideal situation is to incorporate a negotiated subcontract into the teaming agreement itself. Next slide, please. So let's look a little bit at the scope of the terms that are involved. We obviously need to talk about this in the context of the solicitation or the program that you're seeking to obtain. But one needs to talk about the relationship of the parties. What are their respective duties in relationship to each other? What are they going to do with regard to developing the proposal? Who's going to take the lead? Who gets to talk to the customer? What are the limits on exclusivity? What are your future contract expectations? Now that we've talked about enforceability, this aspect of the teaming agreement obviously becomes critical in talking about potential subcontract terms, pricing, scope, things like that. If one is unwilling to do the hard work at the teaming agreement level, the likelihood of an enforceable agreement is less likely. One wants to talk about the term, the duration, how to terminate. We've talked about that before. We certainly want to talk about in a teaming agreement how we're going to handle non-disclosure and confidentiality of proprietary information, and we want to project how we're going to deal with IP. I might note that if you have a critical teammate, you might also want to build in the right for due diligence, additional due diligence, and you may want to insist upon escrowing critical IP or technologies. Next slide, please. So the other things that come into a teaming agreement, these are less critical, and teaming agreements are longer or shorter depending on how many of these terms one might want to include. But often there's a sensitivity when one's entering into a teaming agreement of whether someone's going to steal one's employees. And so there's no solicitation clauses. One obviously needs both ways to deal with OCI, conflicts of interest. How are you going to deal with costs? Disputes in governing law obviously is critical for the reasons we talked about above. Termination we've talked about above as something that one doesn't want to allow if negotiations fail. Limitations of liability and indemnity may become important during this process. There are terms about legal compliance, and one again may want to deal with the flow down provisions. Again, one needs to pay attention that these might evolve between the time of the teaming agreement and the subcontract, so one wants to be careful about that. And then there are the boilerplate clauses, which we've set out, and there are obviously others. And so that's the basic core of a teaming agreement. Let's turn the page and talk about one couple of special circumstances. We've talked about the mentor-protege program above, but I did want to note the GSA scheduled contractor or teaming arrangements, which is not a teaming agreement per se. It's a special rule under the GSA schedules where two GSA schedule holders can negotiate and come together in a CTA teaming agreement approved by the GSA, where both of them are prime contractors. They combine the talents or products on their respective schedules to provide a solution. Both are acting as prime, although one is in the administrative lead. Next page, please. I wanted to thank you for spending part of your day with me, and just as a wrap-up, the takeaway is that teaming agreements require careful consideration in the context of their overall business goals and needs. And negotiating a teaming agreement should be a thoughtful exercise that aims for an end which will result in a subcontract agreement that will lead to a successful endeavor for both parties. I thank you for your time. If you have any questions, I hope you'll email me at the address or call me at the address on the current slide. And with that, I turn it back over to the Jennifer Schaus team. Thank you very much.
Thank you so much, Anthony, for joining us today. Like he said, if you have any questions, please reach out to him with the phone number, email shown on your screen. And this concludes the webinar. Thank you, everybody.